Many people face this question during their research work that can they rely on a foreign decision or an academic article in court? This is because during their research they come across a well-reasoned foreign judgment or a neatly written article explaining the law. But they are unsure that will the court accept this or will it help their arguments or weaken it? In litigation, it should be kept in mind that using wrong source at the wrong time can quietly harm your case. So, in this lesson, we will discuss when using a foreign decision or an academic article helps and when relying on it is a mistake. People turn to foreign judgments or articles because Indian case laws may be limited on that subject they were researching. The issue feels novel or the reasoning appears clearer. So, there is no problem in looking beyond the domestic law. The problem arises when these are used without understanding their position in the hierarchy of authority. Litigation follows a simple, unstated rule about foreign judgments and articles. These judgments and articles can persuade, but they can never substitute binding law. They are helpful only when domestic law is silent on that issue, the issue is genuinely unsettled, and the foreign reasoning is aligned with the Indian legal principles. You need to understand this very clearly that if Indian law answers the issue, then these judgments and articles add little value. Foreign judgments are not rejected simply because they are foreign. They can be helpful, but in limited situations. First, they can help when the concept itself comes from the common law traditions. Many principles in Indian law have evolved from common law reasoning. In such cases, these judgments can help explain how those legal principles have developed. Second, foreign judgments may assist when Indian courts have already relied on similar foreign reasoning. In that case, these judgments are not a new authority. They only assist a line of reasoning Indian courts have already accepted. Third, these judgments are more useful in matters involving interpretation of legal principles rather than direct interpretation of Indian statutes. Often, in these situations, foreign judgments can provide conceptual clarity, support the reasoning, and guide the interpretation. But even then, they should be used carefully as supportive material and not as the foundation of the argument. Foreign judgments can hurt when they contradict with Indian statutory schemes, they ignore local context, and when they are used to bypass the binding precedent. Courts may react negatively if they feel Indian law is being ignored, foreign reasoning is being forced, and the arguments lack domestic grounding. Remember, this can damage credibility quickly. Academic articles often sound persuasive. They are structured, analytical, and are confident in their words. Academic articles generally are opinions and not law. They reflect scholarly debate, but not judicial determination. And obviously, they do not bind anyone. Yes, academic articles can help in explaining concepts, showing academic support, and contextualize arguments. But even after that help, they cannot replace statutes or judgments. People misuse these foreign judgments and articles because databases make them easily accessible. They often sound authoritative, and when to avoid them is rarely explained anywhere. This is the reason why people use these foreign judgments and articles as binding and commentaries as precedent. But you should always remember that in litigation, it gets noticed immediately. A safe and practical rule is this: use Indian statutes first, then use binding Indian judgments next, and then, if necessary, Use foreign judgments and articles only to support your arguments and not as the main authority. Always keep in your mind that if foreign judgments and articles are doing the heavy lifting in your arguments, then there is something wrong. When you use foreign judgments or articles, then always acknowledge their persuasive nature, connect them with Indian principles, and explain why they are relevant, and never present them as settled law, decisive authority, and as replacements to Indian precedents. Remember, in courts, matters as much as substance. So, understanding when to use foreign judgments and articles requires maturity. But the research still has no value until it converts into arguments, right? The next lesson is the most important part of this series, where we will discuss how to translate legal research into written submissions and oral arguments so that the research actually works in court. Thank you.